Supreme Court Project by Isabella Marino and Michael Morales. You know who this is? You probably don't, but he's not the famous NBA basketball coach. This Fred M. Vinson was the 13th Chief Justice of the United States Supreme Court, and he was involved in 3 landmark cases. Vinson was born on January 22, 1890, in Louisa, Kentucky. His father was James Vinson, a county jailer, and his mother was Virginia Ferguson. He graduated from Kentucky Normal School in 1909. Vinson got a BA in Law Studies at Centre College in Danville, Kentucky in 1911. Vinson achieved the highest grades in history of the school and earned multiple scholarships. Vinson enlisted in the Army in 1917 and was a soldier in World War I, and he returned to Louisa without seeing combat. Vinson was elected the Commonwealth Attorney for the 32nd Judicial District of Kentucky. In 1911, Vinson opened his own law practice at the age of 21. In 1937, Vinson was nominated by President Franklin D. Roosevelt to fill a vacancy in the United States Court of Appeals for the District of Columbia. He was appointed by Chief Justice Harlan Fiskett Stone to serve as the Chief Judge of the United States Emergency Court of Appeals. He held this position until 1943. He was appointed as Secretary of Treasury by President Truman in 1945. Vinson was involved in the court case Sweet v. Painter in 1950, which helped buy the foundation for the landmark case Brown v. Board of Education in 1954. In 1953, he died suddenly from a heart attack before he was able to vote on the case. After Vinson died, Justice Earl Warren was appointed Chief Justice. Vinson was the first of few people to have occupied positions in all 3 branches of the federal government. He was Chief Justice at the Supreme Court for 7 years. Vinson was a conservative, but he supported FDR during the Social Security Act. In 1924, Vinson was elected to the U.S. House of Representatives as a Democrat. Whitney versus California, 1927. Where did this case originate? Charlotte Anita Whitney was a founding member of the Communist Labor Party of California. The case originated in California. Whitney was prosecuted under the California Criminal Syndicalism Act for helping to organize a group that thought to effect economic and political change through the unlawful use of violence, although she argued that she never intended the organization to act this way. The case was first argued on October 6, 1925, and re-argued on March 18, 1926. The case was finally decided on May 16, 1927. Whitney was prosecuted under California's Criminal Syndicalism Act. Whitney's organization was planning to overthrow the government using violence. The court case made the Criminal Syndicalism Act stricter in a way, as well as assembling with any society group or assemblage of persons formed to teach, advocate the doctrines of criminal syndicalism. Freedom of speech, guaranteed by the First Amendment, was not an absolute right. Whitney led a campaign for a women's suffrage amendment to the California Constitution, and then joined in similar campaigns in Oregon, Nevada, and Connecticut. She joined the Communist Party and was later arrested after a public address at the Oakland Center of California Civic League on 5 counts of criminal syndicalism. She was sentenced to 1 to 14 years in jail. She ran for the Communist Party treasury and polled more than 100,000 votes. Whitney became an officer in the Communist Labor Party of California, which was devoted to the enhancement of the political power and economic strength of the working class. As a defendant, Whitney claimed the action she took as a member of the Communist Labor Party of California posed only a remote potential harm to the public, and she was involved only in contributing to the preparation events by the group. In 1927, 8 years after her Supreme Court case, she was convicted of election fraud, and in 1936, she became the national chairwoman of the Communist Party. Whitney was nominated for the U.S. Senate by the Communist Party twice, but she ended up losing both elections. Charlotte Anita Whitney died in 1955 at the age of 87 years old. Her name will forever be associated with one of the most important First Amendment cases ever heard by the United States Supreme Court.